Hello, everyone. We're still probably going to have some more people trickling in, but I'm going to go ahead and start with explaining what we're doing today. So we're doing a healthcare basics in honor of National Healthcare Decisions Day. We'll be covering a couple different topics, and we will be taking questions at the end of the presentation. If you have any questions throughout the presentation, please feel free to use our Q&A function to submit those right away. You can also upvote other people's questions if you see questions that's similar to yours or that you'd really like to have answered. Any upvoted questions will be the ones that we'll be answering first. We have a few speakers here with us today. I'm going to go ahead and start introducing everybody. Today we're going to be joined by Susan Kimble with Stoel Rives PLLC, Michael Terasaki with Washington Pro Bono Council, Hamburger and Robbins Greene from Sirianni, Youtz, Spoonemore and Hamburger PLLC, and Sam Conley, who's a registered nurse, who's going to be sharing some of her lived experiences and insight into these different types of forms and experiences that you can have in the healthcare district. Please give a warm welcome to everybody, and let's get started. Susan, I'm going to turn it over to you. She's going to go over what specifically we'll be covering in today's webinar and start us through kind of why we're here and what's really important about these documents.
Thank you so much, Ronnie, and thank you to everybody at QLaw. This is a really exciting event that has been not very long in the planning, but we're super excited that it's come together, and these are really important topics to be talking about and learning about. So this evening we're going to cover powers of attorney for healthcare, and different types of powers of attorney, healthcare directives as well. We're going to talk about both of those kinds of documents. They're both legal documents that you can execute and have in place for free. They have some similarities, but there are also some important differences, and we'll talk about those in more detail as the webinar goes on. We'll then move on to talk about travel letters and travel in general with minor children. And then finally, Ellie and Ari will share some really helpful information around resources and how to navigate insurance coverage denials. So the first topic is going to be the powers of attorney and healthcare directives. And we can go ahead and advance the slide. There we go. So as I mentioned, these are both legal documents, but they have different focuses. The easiest way to think about them is a power of attorney focuses on a person. So giving another person some legal power, whether that legal power is related to healthcare or finances, you are giving another person some legal power. A healthcare directive focuses on preferences, so expressing your preferences with regard to healthcare treatment that you might receive in the future. We encourage everyone to put both of these documents in place. We'll be sharing some examples. Michael is going to walk us through some specific documents that meet legal requirements in Washington later in the webinar. But again, just as a reminder, these are free documents. It's absolutely free to put these in place and to have these executed. While talking about these documents can sometimes be difficult because you're talking about decisions and your preferences should you not be able to speak for yourself, it's really important, and it's a really good step that we can take to protect ourselves. We're really, and I think we can advance the slide, sorry. The last few months have felt, to me personally, very out of control. And as an attorney and a healthcare attorney, I struggled personally and professionally to identify things that I can do, steps I can take that are meaningful, that actually make a difference. This webinar is being presented because from a legal perspective, and as you'll hear about from Sam, who's very gracious to join us in just a minute, from a clinical perspective too, having these documents in place can absolutely make a real meaningful difference. It's something that each person can do to take back a little bit of power and control. With these documents in place, it does not matter your gender, your sex, your race, whether you are married or to whom you are married. What matters is that the legal document, that legal protection is in place, written down, and reflects your wishes. Um, so with that, I will ask Sam. She is going to share with us. Sam is an RN registered nurse, and she's going to share with us some of her experiences.
Yeah, hey there, guys. Thanks for letting me speak today. So I'm a registered nurse. I work at Harborview, and I work with neuroscience patients. So a lot of folks who've had brain injuries, strokes, a lot of instances where they really can't speak for themselves, and a lot of instances where folks maybe have these documents in place or where they don't. Once you've had something affect your ability to communicate, you can't make these decisions anymore. You can't appoint someone. So things happen based on legal next of kin, which I'm sure they'll discuss more later. But I see a lot of interesting things happen at the bedside. One kind of framework that I like to bring for folks to help them understand the experience you're going to have working with the healthcare field is that every doctor, every team, physician team you focus on, especially in this kind of inpatient, acutely ill setting, they tend to be focused on one body system. I think of them as like goalies on the net. They're not going to let anything happen to that one body system, but they aren't trained to think about you as a whole person necessarily, or to think about the ways in which what they're doing to you to fix this one problem, how that may affect you in another way in your life, and how that might not be something you want, or at least it would be something you'd want to consider. So I find that doctors themselves aren't always great at having these conversations. They aren't always good at helping explain the full implications of the treatments they're advising and the things like that. So that's this kind of perspective on Western healthcare and Western medicine means that it's helpful to have someone, what you pick as your durable power of attorney for healthcare, who is going to focus on the things that you care about, who's going to think about not just how long you're going to live, but how comfortable you'll be while you're living, or how independent you'll get to be while you're experiencing these treatments, or whatever it is you're going through. So those are things that people understand usually from your living will, from the power, from the document where you say what you'd like for your health care. What's tricky is that a lot of documents say either do everything or do nothing. We don't always have a great set of ways to kind of understand the nuances of what people value and how to make real decisions based on the document in front of us. So things like having feeding tubes, having other kinds of lines in you to promote your health. Say you can't swallow well now and you need help getting nutrition and hydration. Those tubes can be really uncomfortable. And the experience of having to have them put in someone and kept in you, maybe if you have difficulty communicating, can be pretty traumatic. And so I think that it's when the rubber meets the road in terms of healthcare and these documents is the truth is just that your power of attorney, the person who's going to be speaking for you, is going to be the one who really makes that the decisions that you've made and into reality. I've unfortunately found that in real life, if the person doesn't want to do whatever you've said you want them to do, say, you said you didn't want any treatment. If they come in and they say, well, I think they would have changed their mind, I don't agree, I want you to do everything. The reality is the healthcare team does what the person says, not necessarily what your document has said. And so not great, not my favorite thing as a provider. Certainly that creates a lot of moral distress in your medical team. But at the end of the day, we have to listen to the person who's at the bedside speaking for you, which is another reason why I think it's so important to pick the right person who's not just going to ask doctors hard questions, not just know you really well, but is also going to think about the ways in which you want to live and how you want to be treated while you're there. I had a patient who had gotten really brain injured and he'd been living independently for a long time, right? Like grown adult, but he's not married and he didn't have any documents saying who he wanted to be his decision maker. So his legal next of kin was his mom, alone. She was his only decision maker. And so she decides everything from here on out. So she decided that the ex-girlfriend is the best person to be around and the new girlfriend is not good news, so she wasn't allowed to visit. The ex-girlfriend came and was there. So it's not always the case where you yeah, if you haven't set out ahead of time exactly who you want to make these decisions for you, it could be someone that you wouldn't have picked, and who would maybe make decisions in a way you wouldn't agree with. um Yeah. So I think that's my I don't have too many specific stories of I have some sad stories of times where I've found parents have made the right decisions. I often find it's hard because parents don't like making hard decisions based on their children's health care. And I have found that adult parents of adult children have made the hard decision. You know, my loved one wouldn't want to live like this. I'm not ready to see them go, but I know that they wouldn't want to continue this way, and I need to respect their wishes. Um, I don't find it's as common as I think we would wish it to be. And that's why I think these meetings like this are so important. It's not just about, being respected in the hospital. I think it certainly is. But it's also about getting to have an end that feels true to who you are, and not being forced to live in a way that you wouldn't find agreeable. And I do see a lot of that. And unfortunately, in healthcare, if we don't know for sure that you don't want this, we generally assume you do. So again, the documents where you outline what you do and don't want, really important, but most important, picking someone who's going to be really true to you and your wishes, and someone who's got a little bit of mental toughness, because it's hard when your loved one is sick and doctors are going on and on. Even as a nurse, I can understand feeling really out of your depth with a lot of the medical teams, and the complexity. So having someone who's really resilient and capable can be really helpful, especially when they're probably going through something emotionally if you're going through something. So yeah, so those are my thoughts from a very specific siloed view of healthcare. And I'll pass it back to Susan. Thanks so much.
Thank you so much, Sam. That was really helpful. So you might be wondering, if you don't have a power of attorney and for healthcare in place, who is your decision maker? What happens? And as Sam mentioned, that is your legal next of kin. So what would happen right now if I lost the ability to make or communicate my own choices and I don't have a power of attorney for healthcare in place? In Washington, this is the list of people that your doctor, your healthcare team will look to make those decisions. Most people do not have a court-appointed guardian, so we'll sort of jump over that one to spouse or registered domestic partner. This is not your live-in partner of 25 years or any other informal category. You have to be legally married or a legally registered domestic partnership in order for this to stick. If you do not have a spouse or domestic partner, we go down the list. So your parents, your adult children, your parents, your adult siblings, and on down the categories. There are a couple of important caveats here. When there is a group of people, so like your parents, if you have two parents, or your adult siblings, if you have, more than one sibling, when you have a group of people, all the people in that same group have to agree on the decision. So if you are thinking that you've got one cool brother and he's going to make the right call and the rest of your siblings won't participate, unfortunately, that does not work. You need to name your cool brother as your power of attorney for healthcare to make sure that that person is given the power to speak for you, because otherwise everyone else in that same category can essentially block the decision that one person would make that you would deem to be a good choice. The other caveat to this is, and I have seen this as a former in-house lawyer with a couple of different health systems, I have seen this play out so many times. When there is an emergency or a patient loses consciousness or the hospital needs to find a family member to be the legal decision maker, the next of kin decision maker, they sometimes scramble to find someone, anyone on this list of family. Google, Facebook, those are great tools, but they don't always result in success. People don't answer the phone, people screen numbers they don't know and they don't answer. And if the hospital cannot find or identify or reach your adult children, for example, or your parents, for example, they move on down the list to try to find anyone on this list. And sometimes the situation comes down to who can we find that we can reach that's willing to participate. So the list seems, on paper, it seems really clean, but in reality, it's often much more complicated, especially when decisions are time sensitive. So if you have a power of attorney for healthcare in place, that person is the person that makes decisions for you when you are unable to make decisions, even if your child or your parent or your uncle disagrees. Your POA is the person. And then one other note just about other states without a power of attorney in place, if you're traveling, for example, other states have similar but sometimes different lists of priorities. Some states do not recognize domestic partnerships. And just to be really candid, like lawyers don't know what is going to happen in these next few years in terms of marriage laws. And it certainly could be that another state does not recognize a legal marriage. And so really, from a legal perspective, having a power of attorney for healthcare is the safest, most solid tool that we have available to address this uncertain situation. Next slide, please. Thank you. So as we've talked about, power of attorney names the person, your person, that you want to make decisions for you if you are unable to do so. These can be healthcare decisions and a power of attorney for healthcare. They can be financial decisions, like opening or closing a bank account, paying your rent, selling your car, things along those lines. And the document lays out what the powers are. In a minute, Michael is going to walk us through some of those details and how to fill out a power of attorney form. A healthcare directive, again, talks more about preferences. What would you want to happen if you were in a car accident and unconscious? Would you want CPR? Who would you want to visit you in the hospital? What is important to you? Those decisions and those preferences are important to define and can help support your agent, that person you name in your power of attorney, in guiding them to make decisions consistent with your wishes. So thank you. So different purposes between these two types of documents, but some common requirements for both powers of attorney and healthcare directives. They have to be written down. They have to be signed by you. They have to be notarized or signed by two witnesses. These are non-negotiable legal requirements. If these things do not happen, the likelihood is that the document is not going to be read as valid. There are some wonderful notary resources available through QLaw. Also, some banks offer free notary services. Some hospitals offer free notary services. You have to ask. I will note for financial POAs, so not a healthcare POA, but a power of attorney for finances. If you want to give someone that authority to deal with your banking information, for example, it is generally better and more effective to have your power of attorney notarized as opposed to witnessed, just because some banks prefer it, candidly. Legally, either a notary or two witnesses is sufficient, but you likely will have a smoother experience at a bank with a notarized power of attorney for financial decisions. when you are naming your agent in your power of attorney, whether this is a healthcare power of attorney, a financial power of attorney, literally the only legal requirement is that that person is an adult, so 18 years or older. It does not have to be a family member. It can be a family member. It does not have to be your spouse. It can be a friend. It can be a blood relative, and it can change over time if you change your mind. Relationships change over time, and it's important to keep in mind that that this decision is your choice. And as Sam explains, that person is going to have a really important role, and so you want to make sure that that person um, is your person. Part of the point of or intention of Healthcare Decisions Day, which is today, is to encourage everyone to execute these legal documents, and if you've already executed them, to think about them, to think about the decisions that you have written down, and are those decisions still good? Do they still reflect your wishes? So how do you know who your person is? Think about the person in your life who knows you, who you would want to have these hard conversations with, who you would want to talk about these decisions with, who knows what you would want at the end of your life. Once you decide who that person is, talk to them. Tell them that they are your person, that they are your agent, that they have your power of attorney for healthcare, or whatever power of attorney document you're executing. Tell them why you chose them. Give them a copy of your power of attorney and your healthcare directive, and talk to them about the preferences that you've written down. Ask them if they have any questions. It's a hard conversation, again, but it's really important. It's a really important legal protection to have in place. So as I mentioned, Michael is now going to walk us through some of these documents and give us a little bit more detail about how to fill them out.
Hello, everyone. My name is Michael. I'm an attorney. I work with the Washington Pro Bono Council, and one of the things I do is I kind of work with different organizations throughout the state to try and get advanced planning documents like powers of attorney, like advanced directives, in people's hands and completed. So I'm really happy to be here and be able to talk to you all today. So we're going to be talking about a few different specific kinds of documents today, and we're going to start with the power of attorney documents. I have them listed here as two documents, a durable power of attorney for healthcare and a durable power of attorney for finance. Um, it is also common to see them combined into one, and that can be fine. But I'm going to be talking about them as two different documents because the forms that we generally use are two different documents, and they really do different things. When I explain power of attorney documents to groups when we're talking specifically about healthcare, I often get questions about why are we talking about the finances? And unfortunately, the reason is because the American healthcare system is pretty intertwined with financial things. And there are situations where a financial power of attorney can be really useful to help get the care you're trying to get, or sometimes it's even necessary for things like coordination of benefits, different placements for lower levels of care, and moving to different healthcare facilities. So we've got this little chart here. Broadly speaking, on the left, we've got our durable power of attorney for healthcare. And the goal of this is to let someone else make these decisions for you if you're not able to make them for yourselves. I also like to mention power of attorney for healthcare can be a key to getting decisions that you are still making for yourself carried out. You know, just to have someone else who can help be an advocate. Maybe you're still able to make all your decisions, but it's difficult for you to do communication things for the time being, and work with your healthcare providers. The typical powers we have listed here, admitting or discharging you from a hospital, making decisions about medical treatments, accessing your medical records and handling healthcare bills, deciding who can visit you in a hospital. The goal of the document is really so you can have someone else that will be able to try and make the same decisions they think you would make. So, the goal is really for you to be able to get what you want, carried out, not necessarily to pick someone to substitute all of their judgment for your healthcare decisions. Like I said, we are going to talk also about financial powers of attorney. And this does kind of like what it sounds like. It gives someone else the authority to handle financial matters for you. Um, and like I said, we bring it up because sometimes the power of attorney for healthcare only gets us so far. It's good enough for many healthcare situations, but if you have particular healthcare needs that are really complicated or are really kind of long-term placement related things, or there's a lot of different insurance companies and government benefits, maybe that have different kind of asset thresholds and things that need to be monitored. Power of attorney is really something that's important and can help you get your care taken care of on the healthcare side while making sure your finances are matching up with what needs to be done. So I'm going to go pretty quickly through a typical sample for each of these documents. Um, let's see, we'll start with the power of attorney for healthcare. Like we talked about a little bit, or the others talked about a little bit, really the big choice is choosing your person. I'm going to be referring to them as the agent because that's kind of how it's written down in the lingo. Your agent is really the person that you trust and is going to be the one who's making decisions if you're not able to make your own decisions. Um, we talked a little bit about some other considerations. Some of these might be repeats, but I want to reiterate some of them. This really has to be someone that you trust. Ideally, you trust them to make the same decisions that you think that you would make yourself. So your partner, your friend, your family. And like we mentioned earlier, this is the person that overwrites kind of the default scheme that the law sets of the person who's going to make decisions for you. So you want to make sure it's the right person. And because we're talking about healthcare, I just want to remind everyone, like, this is a healthcare document. You might have someone who is otherwise a great choice. They're a great advocate for you. They're usually going to know what kind of things you want, but they just can't do hospitals, or they just can't really, they have problems when we're talking about healthcare stuff and blood and needles and things. So, you know, it's important to make sure you've got someone who can do the healthcare part of the healthcare power of attorney. Because ideally, this is someone who's going to be, bedside if they need to, talking with doctors, making informed decisions. So the last thing I'm going to mention on picking your person is make sure it's someone who's okay with this role. In an ideal world, you're never going to use this document. We'll all be healthy forever. But you don't want to go through all the trouble of picking someone, making sure your documents are all in place, and then when push comes to shove, they can't do it. They don't want to do it. So that's kind of my quick list of things to consider and keep in mind. The big choice is really choosing your agent. But I'm going to go through, and I'm going to screen share, I think, off my screen really quickly here to show you what our form that we generally do looks like. And, oh, okay, sorry, I think I need permission to share. Oh, there it goes. Okay. All right, so hopefully that popped up for everyone. This is, if you haven't heard or ever used the Washington Law Help website, I'd encourage you to go just take a look because it's a fantastic website. They've got great forms for all sorts of things. We use their forms for the durable power of attorney and advanced directives forms because they're very straightforward. They're written in plain language. And I've highlighted a few things that I'll go through, but I'm not going to go through every detail here because we do have a little bit of limited time. So, I encourage everyone to take a look afterwards, take a look at the forms. But like I said, the big thing is your agent choice. That's your person. Highly recommend you also pick an alternate, maybe even a second alternate. Um, like I said, ideally, we're not going to be using these documents ever, but if you do use them, they may be years from now. So let's make sure you've got at least someone kind of in the wings ready to go. I like to highlight this section that just states that you don't sign away all your rights when you fill out one of these documents. I get questions from folks with power of attorney documents. They say, well, I still want to be able to do everything. You don't give away any rights by filling these out. You keep all your rights. This is for if you can't make your own decisions and you need someone to step in and help. I think we mentioned earlier, but the word durable in power of attorney, that means that that means it continues to be operative even if you can't make your own decisions. So the documents we're looking for, we want to make that people ask, what does the durable mean? That's what the durable means. I also like to highlight that this isn't a forever permanent thing. You can revoke this and make a new one. Most forms include a clause or a section in the power of attorney document that actually says I revoke whatever I had before. So you can be sure if you make a new one, it'll be the appropriate and active one. I'm going to scroll down real quick. There is a section here that kind of reiterates what the statutory kind of like legal authority that a power of attorney for healthcare does. Gives your agent the ability to do all the things that you could do, make the decisions that you could make. And then the last couple things I'm going to highlight on this form are the government benefits section. A lot of forms will say specifically they give the authority to manage and coordinate government benefits. This is the section where we have seen a financial power of attorney is additionally needed in addition to a healthcare power of attorney. So that's I bring that up just to kind of remind everyone that there is also the financial one, and we want to make sure we're paying attention to that one also, particularly if we're looking at like really complicated government benefits, applying for new benefits, that sort of thing. And then there is this section about mental health care treatment. There are some things that your agent cannot authorize under most power of attorney documents. I'll talk a little bit about the mental health care advance directive later, but specifically, involuntary commitment to mental health treatment, things like psychosurgery. So if those are things that might relate to you, take a look at some other documents. There's other ways to plan for that and coordinate for that, but you're going to want to make sure you don't just rely on this document for those things. So I'm going to stop that screen share real quick, and let's see. Yeah, great. We'll go back. We're going to move on now. Like I said, we're going to run through them really quick. I just want to hit some of the high points. For the financial power of attorney, I want to reiterate, we're talking about healthcare stuff today, but the financial power of attorney, can be necessary in some situations. Some common situations I see are often when you're just getting older and you just need someone to help around with financial things, particularly if there's Medicare and Medicaid and private insurance all kind of coming together to support your healthcare on an ongoing basis. I also mentioned there are some specific healthcare, more complicated healthcare needs. If you're experiencing some dementia and need some dementia-related care, or you're expecting to need some dementia-related care, a financial power of attorney can be a key to making sure you get the care you need in a timely way. I'm going to throw up the sample form for the financial power of attorney in a second, but I want to mention that unlike with healthcare, where there is kind of a default list of folks who theoretically at least will step in to make decisions, for finances, we don't have that. So if you find yourself in a situation where someone needs the ability to take over your finances and make changes and help you with things, and you don't have a financial power of attorney in place, someone's going to have to go to court to get the powers to do that. So that's the other main reason I mentioned the financial power of attorney, is because there isn't a statutory default for this. So if someone finds out they're trying to help you out, even if it's someone you would for sure give them the power to help you with, they're going to have to go to court to get these powers. The same basic kind of format is used on both of these samples. The agent choice, same thing. There's an agent and an alternate, still called the agent. And we'll note that your power of attorney for finances and your power of attorney for healthcare don't need to list the same agents. It can be helpful if they're both the same and that's a person who's a great choice for both. But maybe you don't have someone who's a great choice for both. So note that they can be two different people. You're going to want to make sure they can work together though, because this is a coordinated effort to make sure you get your health care and your finances all worked out. Again, as long as you can make your own financial decisions, you can do that. This document doesn't sign away all your powers. This doesn't create a guardianship where someone takes away all your powers and is able to exercise them in lieu of your own judgment and decisions. Most financial power of attorneys have a start date that is either like right when you sign it or after a healthcare provider says you can no longer make your own decisions. There's pros and cons to both of them. The if you have a document that starts immediately, it can be easier, but not everyone wants to give their agent, full authority to go make changes in their finances right away. So there's different ways to set a start date based on what's going on. The powers that a power of attorney for finances gives your agent are pretty broad. They're able to do pretty much everything kind of routine that you would be able to do yourself. This lists, like we mentioned, working with banks, selling things. It helps if there's something like a car accident that led to the medical situation you're in. This is a document that'll let someone kind of participate in an insurance claim or a lawsuit. I will note there is a section here called special powers. So the financial power of attorney doesn't automatically give all the powers to your agent. These are areas that are generally considered like a potential for abuse or misuse. So if you want your agent to be able to say, give gifts of property or money, maybe even give gifts of property or money to themselves, maybe you don't want them to have that power, maybe you do. This is a list that is checkboxes, yes or no, but your document can be more complicated if you want specific things. And a lot of these are either do or don't apply to your situation. So, creating, canceling trusts. Maybe you're trying to do some Medicare planning and make sure assets are within a certain range so you can make sure you're qualifying for benefits and not losing benefits. But, if that's your situation, feel free to, reach out to me through QLaw. There are people who can help you work through some of the more complicated aspects of that. Okay, so I'm going to stop sharing that screen. Next is healthcare directives. Okay, so the last kind of set of documents I'm going to talk about are healthcare directives. There's, I guess we've got them split into kind of three categories. The advanced directives that are really addressing kind of how you want medical care to go, what we call living will, which is really like end of life kind of specific treatment things. And then the mental health advanced directive, which I'll cover pretty briefly, but that one also is a situational document. If it applies to you, we'll take a look after I give you a brief overview. But that really identifies, what kind of treatments you may or may not want to consent to ahead of time if you're having a mental health crisis. So those are often the advanced directive and living will are just called a health care directive, and they're one thing. We often don't use the word living will because a lot of just colloquially folks hear the word will and they assume it means like, oh, what happens to my stuff after I pass away document. So we usually call it a healthcare directive. And I think like we mentioned a little bit earlier, this is really your chance to write down, what you want. This isn't giving someone else authority to try and make decisions that they think you would have made for your own healthcare. This is really your big chance to write down exactly what you hope your healthcare is going to look like and what it's going to be, including, end of life decisions, what kind of care you want. So, those are two different functions, but they're both with the goal of trying to get your healthcare treatment carried out the way you want. And the healthcare directive can be a great tool for your agent and a power of attorney for healthcare. It can really help them know exactly what decisions you would like to be made and what kind of care you would like. And it can be honestly a big weight off of your agent's shoulders because they don't have to do any guesswork. You've got it written down there. I'm going to share screen really quick on the healthcare directive form. And so this is a form that is on the Washington Law Help site. I think it's a great one. Like you can see it right at the top. It lets you list things that are kind of like values, things that aren't necessarily attached to a specific type of treatment, So, maybe medical technology advances. There's something you haven't even thought of. This will help, let your providers, let your agent for power of attorney kind of guide their decisions based on things they know about you and what kind of values you have around your healthcare. But if we scroll down, I mean, there are some very specific sections that'll be on most healthcare directives. This form is a little longer than a lot of the ones you'll see out of like a large hospital system that are really focused on specifically end of life or specific treatment kind of things. But I did highlight a pain management section. Uh, Pain management uh, can mean a lot of things. So this form has it listed as kind of a spectrum. Like on the one hand, maybe I want to be able to feel no pain at all, but that might mean, that the drugs that make me feel no pain mean I'm not so aware and I don't have too much mental clarity. Maybe that's what you want. Maybe you want the opposite. So that'll let you, a healthcare directive can let you spell out exactly what kind of preferences you have for that kind of thing. Um, a thing I always want to point out is most healthcare directives have something about religious, cultural, ideological preferences around healthcare. This is a good place to write those down. Sometimes that means you absolutely want to make sure the chaplain comes and visit you. Sometimes it means you absolutely do not want the chaplain to come and visit you in the hospital. So it can be really helpful to write that down so no one's guessing. It can help make any time that you're receiving some intense healthcare a little more smooth. The last thing I'm going to cover on this form is artificial life support. This is what most people typically think of when they're thinking of a living will healthcare directive document is what at the very end of my life, what do I want or not want as far as life-sustaining treatment that isn't going to actually make me better again. It's just going to prolong my life. So this form is set up in a way that you check the boxes of the ones you want them to withhold or withdraw. If you want a feeding tube, you don't want to be on a respirator, you can list that here. If I've seen situations where there's a patient in the hospital and they're going under 5, 10 rounds of CPR to just keep bringing them back. And if that's not what you want, this is a good place to write that down and make sure your healthcare providers and your power of attorney for healthcare knows that's what you want so that they can advocate for the things that you've said that you want to have in your healthcare. So this healthcare directive has something about after death. Which is fine, but there's a specific other form if that's something you're really interested, which is a disposition of remains form, and I think that is probably a better way to decide what you want to do with your remains after you pass away. So I didn't put that in any of my materials, so maybe I'll have them add that to the materials sent out afterwards. Let's see. And the last one, the last thing I was going to mention was the mental health directive. So am I running really over on time? Or okay. Okay, great. The mental health care advance directive is, I'm not going to pull one up and show one, but just so I mentioned earlier, there's some things in power of attorney for healthcare that you can't actually, won't actually be enough authority to authorize the certain types of healthcare. And the mental health advance directive is something you can consider, particularly if you want to leave instructions or authorizations for psychiatric medications, or if you want to have really quick access to inpatient mental health care treatment. So, if this is something that you think might be a helpful tool for you, like the other document, there's a lot of space there for writing in specifically what kind of treatments you have received in the past and you think worked or didn't work. It can be a powerful tool to kind of help shortcut you through to treatments that you know work well, particularly if you're not sure what healthcare provider you're going to end up working with. Um, so it's a helpful tool for you to record things. And if you have an agent for a power of attorney for healthcare, this is a really great roadmap to leave for them to be able to try and help you navigate whatever you're going through. Particularly if maybe you haven't been there, maybe your agent for a power of attorney for healthcare is a great advocate, knows you well, but hasn't been super familiar with all of your mental health history. So if I encourage you to take a look at this document, see if it's something that could be useful for you. The templates, so the documents that I showed you are basically kind of like you would print them off, or you can open them up in Microsoft Word or something, and you can fill in check boxes and fill things in. Washington Law Help has some great, what they call, I think they call them navigated interviews or guided interviews, where they ask you questions and you can type in answers, and you'll get to the end of the interview and it'll have a great document there set ready for you to go. I think they have that for the power of attorneys and the advanced directives. And I think they may have one for the mental health directive also. So, if you're looking for something a little more guided, I think that's a great option. Instead of just kind of sitting down with a blank sheet of paper and trying to work your way through it. And I think I had one other thing. And I do want to mention the Washington Law Help site is getting kind of a refresh. It's going to be a whole new platform starting at the beginning of next month, so it should be even easier to use. So I think that's the end of my section. And I think I'm going to go ahead and turn it over to Susan again.
The other thing that I'll mention is a lot of hospitals and health systems have free healthcare directives, powers of attorney for healthcare available on their website. They also have them available paper versions like at registration. And so if the forms on the Washington Law website, Law Help website, are not a good fit for you, they're great forms, but if you want something different, feel free to poke around wherever you get healthcare in Washington. Okay, so we thought it would be helpful to talk through just a couple of situations that hopefully demonstrate some of the laws and the application of the laws. I will note this is very serious stuff. These examples are a little bit silly, and they are intended to promote conversation and to try to get us all thinking. So please know that I take this very seriously, and the issues that these examples raise very seriously. So the first one, so Paul and Derek have been partners for 20 years. They share a life, they share a home. They have talked about what might happen if the worst happens, but they've never filled out any legal forms like a power of attorney or healthcare directive. Paul's in a serious car accident, falls into a coma. Derek rushes to the hospital to be with him, ready to be his decision maker, because of course that's the right thing. But because they were never married, and because Paul never executed any of the legal paperwork, Derek has no legal authority. So far, we're okay, right? So far, Derek may be the person that the hospital relies on to speak for Paul. The problem, though, is that then Paul's parents arrive, and the hospital deems them the decision makers because Derek and Paul are not married, because there is no power of attorney document, and because Paul's parents are standing there as the legal next of kin. Paul's partner, Derek, does not get to participate in Paul's treatment. He does not get to make decisions for his partner. And the idea here is, even if you have been with your partner for years and years and years, even if they know that they are your person and you know that they are your person, the law and your healthcare team does not know that to a degree that they are going to feel comfortable relying on that person over someone who is a legal next of kin as defined in the law. And then the next example is that, so we have Gwen and Hillary. They have 2 kids, and Gwen has won the lottery. So they are quietly sitting on their mountains of millions of dollars. They've kept their situation pretty private, but they suspect that Gwen's sister has figured things out. Then the laws change, and same-sex marriages are no longer recognized in their state. Gwen knows that Hillary is her person. Hillary knows that Hillary is Gwen's person. But suddenly their once legal marriage is stripped of all of its power and authority. Soon after, Gwen is in a serious boating accident while riding their yacht and falls into a coma. Hillary is ready to make her medical decisions, but because their marriage is no longer legally recognized and they never took the time to execute a power of attorney document, Hillary has no authority. Gwen's sister, who has figured things out and thinks she stands to inherit the millions of dollars, shows up at the hospital yelling, "Pull the plug." So the point here, and I've seen this firsthand, family gets weird at the end of life, at situations where someone thinks they stand to inherit money, even with the best of intentions. Stress, exhaustion, sadness, worry, it gets to people. And if you throw in one trouble personality, or again, somebody who sees maybe that financial benefit coming their way, things can get very tense. And while it's not the hospital's intention, sometimes there are legal reasons that someone gets to make decisions, even though everybody knows that's not the right thing. It can unfortunately be the legal thing. So hopefully through some of these examples, both that Sam shared and these made up things, we have made you think a little bit about executing a power of attorney and a healthcare directive. And hopefully you're thinking, great, I'm going to do it. So the next question is, once you do it, what do you do with all the papers? This slide lays out all of the steps to follow. And candidly, I would just, and QLaw is going to circulate the slides at the end of the presentation, but candidly, I would just follow this as a checklist, follow this slide as a checklist. Do not give the original away. You want to keep that original document that's notarized or witnessed with the original signatures in a safe place. Mostly that's because you might change your mind one day. You might want to elect a different healthcare agent. You might have a change of heart about what your wishes would be. Life is weird and it comes at you fast. And so you want to be able to make those changes if you desire to at some point. So keep the original, and then copies galore. Copy goes to your agent, to your person who's going to make decisions for you if you are unable to do so. To your doctor, that can be any doctor, whether that's a PCP or a specialist. That physician has the ability to save your power of attorney for healthcare and your advanced directive, healthcare directive on your chart. You can upload your own copies if you have access to a patient portal like MyChart. You should save a digital copy to your phone or your device, personal device, and name it something obvious. And that's truly, I mean, if you get into a terrible car accident and EMS searches your phone, if you have a document called power of attorney for healthcare, the chances are that they're going to find it, and that is going to be very helpful. If you change your mind, if you decide I want a different agent, I want a different person to make decisions on my behalf if I'm unable to, you have to start over with this process. So the new form, when you execute a new power of attorney or a new healthcare directive, that form will invalidate the old one. But you can also shred or tear up the past original. The best case scenario would be to have a conversation with your old agent, tell them that they are no longer your agent, that you have a new agent. But relationships can get complicated, and sometimes those conversations don't happen. The most important thing is that you talk to your new agent and you tell them, you are my agent. If a patient has multiple powers of attorney, the healthcare team will rely on the one that is most recently properly executed. And again, back to that slide at the beginning, that means it's written down, it's signed by you, it's notarized or witnessed. Okay, so those are all of the slides that we have on healthcare directives and powers of attorney for healthcare. And we're going to change gears a bit at this point and talk about traveling with minor children. So that is one parent, that is both parents, that is across state lines, that is internationally. If you are married or unmarried or a registered domestic partnership, particularly if you have a different last name from your kids, but that is not like a qualifying factor. I would do all of these things that I'm going to talk about, regardless of whether your last names match. If you are getting on a plane or train or some other kind of transportation that requires ID, please consider the following pieces of guidance and advice. Hopefully everything is smooth, but ultimately, my thought is it's better to be over prepared than not. This is just sort of a list of reasons why is it important to have all of these documents in place. Again, like better to be over prepared. You want to be able to have something to point to prove your legal relationship with your child. That is whether your name appears on the birth certificate or not. That is whether you have a second parent adoption situation or not. That this really is traveling with kids, with minor children, under any scenario. So what documents should you bring with you? And this is paper copies, paper documents, if possible, in a Ziploc bag, in a carry-on. So don't check them, carry them with you. I'm not going to read this whole list to you, and I know this feels like a lot of things to gather. It is a time investment, for sure. But again, better to be safe. In Washington, there is a fee to obtain a birth certificate, but you only need to get one. You can make copies of the one certified copy. That's totally fine. The only thing on this slide that I will call out is the emergency contact list does note including your child's doctor. That is because should you be stopped at a border or should your child need health care while you are traveling, your kid's doctor is a great objective source who can confirm who you are, who your kid is, and that you have a relationship with this professional person. So that can be a really good contact to have information handy. The reason I say paper documents is if your phone gets confiscated or runs out of battery, you want to be able to access this information quickly. I will also add, and again, like this is extremely sensitive, but if your child is carrying their own backpack, like getting on a plane, carrying their own backpack for security, you want to consider putting an extra copy of your emergency contact list in your kiddo's backpack, just in case you get separated or something crazy happens. Again, like it is impossible to predict what is going to happen over the next few years. And it bothers me to have to be giving this advice, but I think it's important advice. If your kid is old enough and mature enough to understand, consider having a discussion about the realities of travel, and know that your child might get asked questions by TSA or Customs and Border Patrol, not unpleasant questions, just like, hey, who are these grown-ups that you're traveling with? Is this your parent? So just consider having a conversation with your old enough, mature enough kid to prepare them for answering those questions, particularly if you're standing right there, right? It can be helpful for your child to be able to say, "Yep, these are my parents." Sail right through. Okay, so then I included also just an example, like template travel letter that you can use. Fill in the information, right? Fill in the dates, your name, your children's other parents' name and information. This is generally comes in handy more if one parent is traveling with the kids, and you are not traveling with them. But it can be used crossing borders, checking in, through the airport. It can also be used in healthcare situations if your child needs to go to the emergency room and there's a question about, you know, who you are and who is in the position to give consent for a kiddo to get healthcare. If it's the middle of the night and your phone happens to be off and your partner is traveling with your children, this letter can be helpful to sort of expedite the process on the ground. So we'll have time for questions at the end, and I know there was a question submitted, but I'm happy to follow up at the end of the presentation. I'm going to hand things off now to Ellie and Ari, who are going to share some very helpful information about insurance, coverage denials, and appeals.
Hi, thank you, Susan. So, you have gotten your healthcare directive in order, and you've gone and gotten medical treatment. You come home, and waiting for you is a denial from your health insurer. And we're going to kind of walk through the basic steps of what to do when you get a denial. I want to say at the outset, not a lot of people appeal their denials, and health insurers count on that. While we have this process of appeals, it's supposed to be quick, efficient, easy for people to do without a lawyer. A lot of people don't pursue it. And, I've heard insurance companies say, well, that's because we got the decision right. I'm not sure that's really the case. But I think it's because people feel overwhelmed and intimidated by the appeal process. So hopefully today we can make it a little bit simpler and help kind of guide you on a path to doing these appeals. So the first thing when you get your denial you want to do is figure out what applies. And I know it's hard to kind of figure out a legal question right off the bat, but you get your denial, and it's really important to figure out whether it is governed by state insurance law or federal law. So if you bought the policy yourself or your family, such as through the healthcare exchange, that coverage is governed by Washington state insurance law. And that's good news because our state insurance law is pretty pro-consumer. So you want to figure that out first off the bat. Second, did you get your insurance through your job? Then it's most likely an employer plan, which is also sometimes called an ERISA plan. ERISA is a Byzantine federal law that governs most private employer health coverage. There are some exceptions. It doesn't apply, for instance, if you were a governmental employee, and it doesn't apply to certain church health plans. But in general, if you get your coverage through an employer, your coverage is governed by federal ERISA law. And that makes a big difference in how you approach the appeals process. Now, once you figure out if you're governed by ERISA, the next thing to figure out is, oh, please go back, is if your health coverage is insured or self-funded. This is a little bit harder to figure out. Sometimes if you call your HR department, they'll be able to tell you. An insured plan is where your employer buys health insurance by paying a premium to a company like Kaiser or Regence or Primera. In that case, your coverage is governed by both Washington insurance law and federal ERISA law. So you get all of the good Washington state consumer protections. But most employer coverage is self-funded. Generally, large employers these days have opted to provide health coverage through self-funded plans. And that means that the employer designs the plan and hires a company, sometimes an insurance company, to administer claims. But the risk for the medical coverage is all borne by the employer. And that's why you can ask your HR department, is this self-funded? And they should be able to tell you. This is important because the Washington state insurance law and all those consumer protections that we like here do not apply to self-funded plans, even here in Washington. And it makes a big difference about the timelines and deadlines and how you go forward. So it really helps to figure out at the beginning whether Washington insurance law applies to your claim or whether you're in a self-funded plan. All right, next slide, please. So the next thing you've got to figure out are your deadlines. Most of the time in your denial letter, they should tell you what the deadlines are. When you get an explanation of benefits, they'll usually say something like you have to appeal within 30 days. Excuse me, let me rephrase that. Usually when you get an explanation of benefits, it'll say that you have to appeal within 180 days. There's certain plans where it's a little less, but it's really important to pay attention to those timelines. If you miss that timeline in an ERISA plan that is self-funded, you can miss the ability to fight the denial. And so the timelines really matter. So you look in your letter for the timelines. If you don't see it there, you go look at your what's called the plan document. The plan document, and sometimes it's called the certificate of coverage or the medical policy or the summary plan description. When you look at that document, it is the governing document that describes your coverage and your legal rights. It is not the summary of benefits and SBC and coverage. A lot of times you'll see these charts that have been required to be distributed under the Affordable Care Act. Unfortunately, those charts, the summary of benefits and coverage, those promises are not legally enforceable. And they often do not include the deadlines. You have to actually look at the certificate of coverage or the plan document in order to find out the deadlines. You can call the insurance company, but sometimes the customer service representative doesn't get it right. So you're better off looking at the actual document. And you should figure out the timelines based upon what the shortest timeline could be. So you know exactly how you're not going to miss the date. All right, next slide, please. In the letter that you have, it should tell you, and it's required by law, by both state and federal law, to tell you the exact reason your claim was denied, the plan requirements, whatever it is in the governing document, that is the basis for the denial, and if there's any other information that they need from you to make a different decision. Now, this is what is required by the law, but very often people get letters that do not tell them that. The letters might say you didn't provide any one of 5 things that are supposed to have been provided, and you're left guessing. So we strongly encourage people to write their insurance company or the claimant's administrator a request asking for all of the documents relied upon to make this decision, to make the denial. Usually in your denial letter, it will tell you that you can write to get these documents, and it will provide the address. This is an incredibly helpful thing to do, particularly if you've got 180 days, to do the appeal. A lot of what they send you back, well, let me rephrase this. When you send this letter, and you should always send it in writing, whether email or by letter, return receipt requested, so you have proof that it was sent, or if they give you a fax number, to fax it. Because the legal requirement that they give you this information is triggered by a written request. Sometimes the denial letters say, call customer service for this information. But if you call, they might give it to you, but they might not. The legal obligation to give you the internal file is only triggered by a written letter. And if you send it return receipt requested or by fax, you have proof that it was sent. So we always recommend people to do that. I'll give you an example. In a case we sued Group Health, we had the client request the records. She got return receipt requested. So there was proof that the letter had made it to Group Health. Group Health lost the request, never sent anything. But because we had that proof, it was extremely helpful in the litigation. The second reason why you want to always get this internal file, if you can, if you have enough time to do it, is that every now and then you find information as to the real reason they denied your coverage. Sometimes the denial is straightforward, and what they put in your letter is exactly what they wrote in the internal file. But more frequently than you would expect, we find that the internal documentation shows a different reason for the denial, or shows a completely unrelated reason for the denial. For example, I was representing someone who had been denied residential mental health treatment, and the reason for the denial in the letter was that it was not medically necessary. But the internal documents showed that someone on the appeals committee had looked at the website for the residential treatment center and believed that the description of the residential treatment center was not aligned with delivering mental health treatment. And the person wrote this in the internal file and said, this is just caretaking with a little therapy sprinkled on top. Well, that is not a reason, some facility's website is not a reason for denying coverage. And so getting these internal documents can be really helpful, and more than you would expect, that the insurance company bureaucrats write down their genuine reasons for denials. It just often doesn't make it into the letters. So really important, request the internal file. The other thing that you want to do is get a copy of the clinical criteria or medical policy that the insurance company is using. They will generally identify that in the denial letter, and you should download a copy of it or ask for a copy of it. and take that criteria to your medical provider and ask them if they can write a letter of medical necessity that specifically identifies how all the criteria in the medical policy are met. Very often, medical providers write their letters of medical necessity without looking at the insurance company's particular medical policy. And so they will be writing these letters based upon what they think is medical necessity, but they don't answer the criteria questions in the actual insurance policy. And so the two are kind of talking past each other. The best kind of letter of medical necessity is one that goes through the clinical criteria of your particular insurance plan and makes sure that each criteria is met and describes how that happens. Sometimes your docs will have enough time to do it. Sometimes you can ghostwrite the letter for them and say if you have any changes or edits, make it, but make sure that the letters of medical necessity that you use in the appeal address all of the criteria in the medical policy. Critical next step. If you have any questions about the criteria, the clinical criteria, ask your doctor, ask your provider. Often they'll have a nurse or a social worker who you could talk to about this. And then finally, save everything. Write notes of all your conversations with the insurance company. Save all the letters, emails, and explanations of benefits. And look carefully at the reasons that they're giving you for the denials, because they're often not consistent with each other. Okay, so you've gone out and you've gotten that information. You've got your letters of medical necessity. You've gathered up all this information. What do you need to send? If you have a plan that is governed by ERISA, if you have an employer plan, you must go through the appeal process before you can go to court. And in general, whatever a judge is going to look at eventually is limited to what you send in with your appeal. So what you send in with your appeal becomes really important. If you think you might need to sue over this, then you got to send in everything you might need to prove your case. So a lot of people worry about how to craft the exact right appeal, how to put in the right information without being too overwhelming. I don't think you need to worry about that. My recommendation is put in anything you think would be helpful if you get to court. Put it in your appeal. Put in all your medical records. Put in all the doctor's notes, all the medical history, letters of medical necessity from as many providers as you can. A lot of people spend a huge amount of time on their cover letter. The cover letter is helpful, but to be honest, the internal insurance company folks who are looking at these things, they hone in on the letters of medical necessity. They don't put a lot of attention into your own letter, cover letter with the appeal. They are looking at what the docs or medical providers are saying in the letters of medical necessity. So, do your best with your cover letter, but really the thing that is most important is to have those letters of medical necessity track the clinical criteria. And then include any other documents that they asked for in the denial letter. When in doubt, include the information. It is always better to give them too much than not enough. Okay. So you do not need to use an attorney to do appeals. And I often tell people, it doesn't make financial sense to hire an attorney for an appeal. Your money is better spent, if you have anything like that, to pay your doctor to spend time crafting a really good letter of medical necessity. The first level of appeal, I don't think you need an attorney for, but before you go to an external review, so the first level is internal, and then most plans only have one level of appeal these days. Some of them have two. But then you can go to an external review. And if you think you might litigate over it, you want to talk to an attorney before you go to external review. Here's why. External review is pitched as an independent medical reviewer of your situation, that it's outside of the insurance company. But a lot of these so-called independent medical reviewers are people who used to work for insurance companies. In Washington state, the overturn rate at independent review or external review is not as good as in other places. We've never figured out why, but my sense is that it's because a lot of these medical reviewers are former insurance company medical directors. If you go to external review and you lose, then you have a so-called independent medical opinion that your coverage is not medically necessary. So you've weakened your case even before you get to court. And so that's why it's critically important, if you think you might want to bring a lawsuit, you want to talk to an attorney before you go to external review. Now, there are other ways to get help with the appeals process that aren't about hiring lawyers. If you can't figure out why you were denied, you can call the insurance company or ask them to review the decision because it doesn't make any sense. That happens, and sometimes they will send out an amended letter. Second, if you have a complex or serious health condition, you can ask for a case manager from your insurance company. They don't have to give it to you, and they don't always do, but a lot of times they'll assign you someone. And that person, they will say that they're your advocate within the system. They might be helpful or they might not, but they give you someone who you can call and email for records. They give you someone who might be able to sort out exactly what the reason was for the denial. And in particular, they can sometimes help with getting exceptions that really aren't necessarily available under your policy. So if someone has a serious health problem, I often suggest that they ask for a case manager, knowing that, this person might say they're your advocate, but they're not really. You have to take what they say with a grain of salt, but you should use them for what you can. And then finally, you can sit down with your medical provider and go over the clinical policy that you have in order to figure out, can you meet those clinical criteria in the medical policy? Or if the criteria are ridiculous, what are your arguments for why the clinical criteria are inconsistent with the generally accepted standard of care? So those are kind of the 5 steps for doing an appeal. It feels like a lot of work, but if you don't do it, you're no worse off if you do it and you don't succeed than if you hadn't appealed at all. And there are times when those appeals work. And in any event, should you decide you need to litigate, those those steps are ones you have to go through. So now I'm going to hand it off to Ari Robbins Greene, who's going to speak in particular about gender affirming care.
Hello, everyone, and thank you very much for being here. My name is Ari Robbins Greene. I'm an attorney. I represent policyholders and workers in pursuing their civil rights. And I work with people who have been denied coverage of gender affirming care. And I wanted to briefly discuss a little bit about gender affirming care coverage and protections. This is intended as a very general overview to help folks just get a broad understanding, some of the basics regarding our right to coverage for medically necessary gender affirming care. This first slide, we're just discussing Washington state regulated insurance plans. So, and that will include plans through Apple Health plans, Medicaid plans. If you have a Washington state regulated insurance plan, you should know that gender affirming care must be covered when it's medically necessary. This includes several specific treatments. Here's some examples here on the slide. The common examples: facial surgeries such as facial feminization procedures, tracheal shaves, hair removal procedures, breast augmentation, chest surgeries, revisions to prior procedures, and a few important protections exist under Washington law. Insurance companies cannot label these treatments as cosmetic in order to deny coverage. They're not cosmetic. Any denials have to be reviewed by a provider who has experience in either prescribing or delivering gender affirming care. And these, again, are protections that are based on Washington state law, specifically RCW 4843 0128. And our state is uniquely protective, and that was the result of immense organizing efforts by folks in our communities here in Washington, including a lot of folks who work with QLaw and other community groups. And I really want to emphasize that because that those protections, they wouldn't exist if it wasn't for our communities coming together and fighting for those things. Something that I hope we all can keep doing as it's obviously very necessary. And Washington Health Law, or Law Health, excuse me, also offers excellent resource packet about gender affirming healthcare protections in our state. You can go ahead and check that out if you want a quick reference. For federally regulated self-funded plans, so those of you with federally regulated self-funded plans have some slightly different but important protections. And these are often plans that folks get through their employer, although not always, but in general, that tends to be the case. Is that your plan from your employer is more likely to be a self-funded plan that is regulated by federal law, specifically the Affordable Care Act and Title VII, protects you from discrimination based on sex, and that, for right now, includes gender identity. And courts have ruled that categorical exclusions, meaning healthcare policies that deny all gender affirming care, are illegal. The laws are continuing to evolve. They will evolve in the future. The current protections remain in effect, but that may change. So just want to flag that. Importantly, know when to seek legal help. I recommend speaking to a lawyer if you are denied gender affirming care and your plan denies all gender affirming care. It has an exclusion that excludes gender affirming care. And a lot of times they're worded all sorts of different ways, these exclusions. So you can find in your plan if it lists the exclusions, it might not spell out so clearly this is a gender affirming care exclusion. So there's you're just going to have to look and hopefully be able to identify that in your plan, unless of course you receive a denial on that basis, then it would be identified in that denial somehow. But if you're denied coverage uh, because of an exclusion for gender affirming care or excluding gender affirming care as cosmetic, which we were just discussing, that's illegal in the state. So if you believe your health plan is treating you unfairly because of your gender identity, that's also a great time to consult an attorney. Please feel free to reach out to an attorney. You can reach out to me, and I can provide my email for folks if they are denied gender affirming care and it's because of a exclusion uh, related to a discriminatory exclusion, basically. So in closing, thank you all for your attention. Again, if you have this experience, hopefully none of you ever do, but if you do, you can reach out to me. Every case is a little bit different. Thank you very much for your time. Oh, and I believe I'm passing it back to Susan.
Thanks so much, Ari. I think we have a few questions that were submitted.
So we had a couple questions that were submitted ahead of time that we're going to go over, and then we'll open it to questions from anyone that's attending virtually with us today. The first question that we had pre-submitted was, does anyone have any solutions for organizations or professionals who can serve as healthcare proxies in the event that someone does not have a trusted individual that they can name?
So there are entities that are essentially professional guardianship services. I'm hoping that Michael might have some contacts that he could share. Ultimately, yes, like those services are available out there. I do not know of anyone personally in Washington to recommend. And again, like I know everybody's situation is different, but it really is so important that the person that you elect as your agent knows you and can advocate for what you want, what your preferences are, what you like, what's meaningful, what's valuable. So to the extent that there is even a friend in your life that might be able to serve that role, I would encourage you to pursue that friendship and talk about it with that person.
So much, Susan. We have one other pre-submitted
Wait,
question.
can I jump in on that one real quick?
Absolutely.
I think there are a number of kind of professional fiduciaries out there. A lot of them are pretty expensive, and they can be helpful, particularly if you're looking at someone to fulfill that power of attorney for finance role. I've found a lot of them are pretty hesitant to take over kind of any of the medical decision making. I'll see if I can maybe send QLaw some of the resources that we've used in the past, but I think if to the extent you can find someone that's really a better way to go. There is also in here in Washington, there is an Office of Public Guardianship. There are certain situations that kind of trigger eligibility for different programs through DSHS and the Healthcare Authority. So in a pinch, there are some different emergency situations. But if you're looking to set something up ahead of time, there's some options for financial assistance and kind of financial guardianships, but it is pretty hard to find professional fiduciary who will take over for medical decisions.
Anyone else have anything to add to that one before I move to the next question? Okay, so the next question is, how can providers protect their clients regarding documentation? This person's a little worried about outing clients to government.
Yeah, this is a great question, and unfortunately a really sort of big question. It's not just behavioral health where I think providers are right to be concerned. There are various health apps, tracker apps out there, particularly some fertility tracking apps that have raised concern around government access to private health information, protected health information. And despite those state and federal privacy laws that are in place, the concern remains about access. So the first thing I would say is that informed consent is really important. It's not the whole picture by any stretch of the imagination. And sometimes having, real candid conversations about risk can scare people away, and that's kind of the opposite of what we want to happen, particularly in the behavioral health space. But I do think that informed consent is part of the response here. From a provider's perspective, and particularly behavioral health provider, I think that there are ways to document appropriately and well within the bounds of the rules to capture the details, the appropriate clinical information of a situation, but that do not expressly line out every explicit detail. And so, again, from a provider's perspective, this is called developing a habit and practice. It's something that you do the same way every time. Something that is part of your habit, something that's part of your professional practice. You don't write down every single little thing about that topic or that action. It's like a professional shorthand almost. And you know that every time you write down this particular phrase or this certain phrase, that that means something to you as a clinician, and you can speak and extrapolate on that sort of shorthand. So the example I'll give is actually informed consent. So documentation of informed consent. Your documentation following a consent conversation with a client might read something like, I reviewed risks and benefits of therapy with clients, answered questions, and the client consents. That doesn't really capture all of the details and all of the nuance of the conversation, what you actually said, what the client actually said, or the tone, the feel of what the discussion was. If privacy is a concern, you could consider developing a habit and practice around documentation for those more sensitive issues that, again, meets your documentation needs from a clinical perspective, but also reflects your professional ability to have that shorthand.
Thank you so much, Susan. Does anyone have anything to add to that answer? So I don't currently see any questions from audience members. I'm going to give people a moment to submit any questions that you may have for our panelists to answer today. At the bottom of your screen, you should see a Q&A button. It looks like a little chat with a question mark, and you can submit any questions that you have there. And while we're waiting for any audience questions to come in, do any of our speakers have any closing thoughts or advice? Do you want to make sure that everyone is able to get properly today? Go on ahead.
This is Ellie. I was just going to say, given the uncertainty of what's going on, it makes it more important than ever for people to look at their health policies, appeal denials, and challenge if they feel like they're being treated unfairly in the health system. I know that there's been a lot of litigation, a lot of public reports about what's going on. But the more people stand up for their rights and protect their rights in the health system, the better all of us are. And so, Ari and I, our firm spends a huge amount of its time representing healthcare consumers against health insurers and getting access to the health system. And this feels like a critically important time for people to know their rights and to exercise them and protect them. And so we're here to help make sure that people are able to do that.
Thank you so much. And we do have one question submitted. Would it cost us? I think that they're asking if the state would cover GAC premiums outside of the mandate.
So right now, I'm not sure I quite understand that, but I think the question is for health plans that do not have coverage of gender affirming care, would the state cover it? And right now we have a situation where both state and federal law requires coverage of gender affirming care. And so, our firm is actively litigating on this issue. And, if people feel like they have been denied coverage under a gender affirming care, they should reach out to us. That's something that we're working on. If it shouldn't be that there is any significant extra cost for covering this service. There was a case, the first round of cases back under the original, the first Trump administration over the gender affirming care ban in the military at that time. Recognize that it's not about cost. The decision from judges in the Western District of Washington said that it amounts to budget dust. It's such a small cost. And so, the per person cost of adding gender affirming care to health insurance for employers is extraordinarily low. So it's, in my mind, I think that this is discrimination, pure and simple. It's not about cost. And the folks who are not adding this coverage are doing it out of prejudice, not based on any realistic financial analysis.
Thank you so much. I don't see that we have any more questions from the audience members, which means all of our speakers today did a fantastic job making sure that they were very thorough in the information we were providing. I want to thank everyone so much for joining us today, and I hope that you found our presentation really informative and helpful. Everyone that registered and attended, even if you didn't sign in to attend the full webinar, is going to get sent a copy of this presentation. It's going to have all the links that we talked about to all these different resources. And we'll also be posting the recording of this webinar on our YouTube channel. So if you want to go back and see anything that was shared verbally, that'll be available to you as well. You can always join our newsletter to see if we have any more events coming up. We're planning on doing some more webinars, community education things coming up this year. Also follow us on social media. QLaw Foundation and other organizations like us are trying really hard to remain privately funded and donor funded as much as possible. so that we can continue working without additional barriers that sometimes comes associated with federal funding or state grant funding. So if you want to support our work or you really enjoyed this presentation, please go ahead and use this link we're going to have in the presentation, donate, or just keep coming to these events so that we know that we're doing a good job. Thank you so much, everybody, and I hope you have a great